Scope of administrative law. Administrative law expanded significantly during the 20th century, as legislatures across the world established numerous government agencies to regulate the social, economic, and political spheres of human interaction. The scope of administrative law is expansive and covers three broad dimensions. The scope of administrative law covers rulemaking, adjudication, supervision, remedies, and constitutional overlap. The scope of administrative law encompasses the boundaries, powers, and operational limits of administrative agencies and the remedies available to individuals when those boundaries are crossed. Essentially, it covers everything related to how government authorities make rules, enforce decisions, and resolve disputes outside of traditional courts. Rule-making powers, quasi-legislative, legislative powers, delegated legislation. Administrative authorities frame rules, regulations, and bylaws under delegated legislation. Ensures flexibility in governance while ensuring compliance with statutory limits. Administrative law examines whether these rules exceed the limits set by parent statutes. Doctrine of ultra vires provides example. Environmental regulations framed by pollution control boards. Adjudication of disputes. Quasi-judicial, judicial functions. Tribunals and regulatory administrative bodies decide disputes between citizens and the state. Example: industrial tribunals, consumer forums, ensures speedy and specialized justice. Administrative law ensures these bodies strictly follow the principles of natural justice. Audi alterum partem and nemo judex in causa sua. Remedies for citizens. Writs, mandamus, certiorari, prohibition, quo warranto, habeas corpus. Mechanisms to challenge illegal administrative orders via constitutional remedies. Writs under Articles 32 and 226. And statutory appeals. Statutory appeals and damages for misfeasance. Purely administrative, discretionary actions. Executive decisions like granting licenses, tenders, land acquisitions, or preventive detentions. It ensures discretion is exercised reasonably, without malice or bias. Constitutional overlap, procedural guarantees. Administrative law operates within the framework of constitutional guarantees. Application of natural justice, fair hearing, absence of bias. Articles 14. Equality. 19. Freedoms. 21. Life and liberty. Act as safeguards against arbitrary executive action. Thus, administrative law is a practical extension of constitutional principles. Government liability. Accountability of the state in tort. Public corporations. Regulation of statutory corporations and public enterprises. Administrative supervision. Courts exercise judicial review to prevent arbitrariness, bias, or excess of power. Ensures compliance with principles of natural justice. Control of discretion. Administrative law limits how discretion is exercised by officials. Prevents misuse of power and protects individual rights. Importance in India. Operates at the intersection of constitutional guarantees. Arts. 14, 19, 21. And delegated legislation. Protects citizens against arbitrary executive action. Provides mechanisms for efficient governance in a welfare state. Scope equals organization plus powers plus procedures plus remedies plus control. It ensures that administrative authorities act lawfully, fairly, and accountably in a welfare state.